So, and then I think a lot of the other arguments, so we went on this, COLAs are outside of the scope of the non-convertible right, and as a matter of statutory interpretation. And further, there is no even, there's no contractual right to that COLA benefit. And additionally, I think what Judge Hurd was saying when he interpreted the non-convertible right in the context of the debt limitations clause, the appropriations clause, was much the same analysis this court went through in JDA 1, where it strived to interpret the statute consistent with the limitations upon the legislation imposed by the debt limitations clause.
But how does the debt limitations clause apply here? Your adversaries say it doesn't apply because the money is already in the pension fund to pay these COLAs, at least today. Tomorrow, who knows, maybe not the day after tomorrow, but they say the money's there. You don't have to appropriate anything in order to pay the COLAs today. So how does, in light of that argument, how does your debt limitation argument play out?
Well, sure. Well, the debt limitations clause precludes one legislature from imposing a financial burden on future legislatures, right? And each legislature, each is a subject to appropriation. And what their theory of that the debt limitations clause is irrelevant would mean that and when they have no right to the corpus of the funds, that the legislature doesn't have authority. Because eventually any money coming in any money coming out has to go in. And no one legislature can obligate a future legislature to put that money in. That's why the debt limitations clause is important, because each legislature, through the Appropriations Act, reaffirms or impliedly suspends prior financial arrangements. And that's the language application burned. So that's why the debt limitations clause matters, is because it goes to the very issue of formation and what the legislature was authorized to agree to. It cannot agree by contract, by statutory contract, to obligate future appropriations by the legislatures. And to say that just because the money is in the pension fund for the benefit of retirees and members, and to which the members and retirees have no right to the management of it, or the body itself, is to obligate the legislatures to fund that system. So that's where the debt limitations clause, the appropriations clause, it just informs the interpretation of the non-convertible right. And I think that's where Judge Hurd was going with that. So the requirement of specificity is a fundamental part of the contractual analysis. Is that and SPINA and the federal courts, whatever variation of the language they use, explains that legislatures make policy, not contracts, and the court should be most clear and cautious in interpreting a statute to apply a constitutional route. Part of that caution, part of that inquiry, is in the contours of the obligation. That comes right out of National Pacific Railroad. And this court in JDA 1 did go to analysis on the specific contours of what right was afforded. So the burden is on plaintiffs to demonstrate that any individual legislator, knowing and reading the non-convertible right statute, would have clearly understood that COLAs was within its scope. And they simply cannot do it. COLAs are nowhere mentioned. COLAs are nowhere referenced. The Pension Adjustment Act is not mentioned. And the burden is on the appellants to make that showing, and they have not done so. Our court has explicitly rejected the contractual basis for employee retirement benefits. And our Constitution provides no constitutional protection in that way. And then you get into the three prongs analysis, but our position is that they have not even gotten to the first sub-inquiry, as the Robertson Court frames it, which is there a contract in this specific term?
Well, let's assume hypothetically that there is one. That we do find there's a contract. Would the remand be required to address that issue because the trial court didn't address it at all?
I think, with respect, the brief lays out why there is no substantial risk. So I agree with Mr. Nowak, there's a three-prong analysis. The second one being a substantial impairment. because there's been no reduction in the benefit, and nobody, Chapter 78 took not a dime from anybody, and you have no, as Will explained, you have no right to future holds that have invested, the court can conclude that the record before the court demonstrates there's no substantial impairment. If the court gets to the third prong, I think we drop in the footnote here, we do acknowledge that remand on that third prong. That the court nobody's really talked about the sovereign immunity, but I think with respect to the federal claims, two lower courts have determined, based on 140 years of unbroken U.S. Supreme Court law, that states are immune from federal contract clause claims that seek to compel specific performance by the state.
I have a quick question.
Yes, John.
Are there any other appeals that you know of dealing with this same issue? I mean, in
With
the
Chapter
one
78,
going on
Your Honor?
right now, in the state?
With Chapter 78, Your Honor?
Yes.
I think, and looking at Ms. Whedon, I think between these two, I think there actually is one more appeal that lays out, I think it's Mr. Fox's case, that kind of lays out similar claims that are before this court on 2010 Chapter 2. It violates due process for certain changes. This is the most, these two are the ones most directly to the pension benefits.
Any questions? Judge Carroll, do you have any questions?
I do not, thank you.
Okay, very good. We think we have heard sufficient argument